Hello and good evening, everyone. I am Sahil Pawar, working in the Investor Education Department of NISM. NISM is the capacity building initiative of SEBI. We work at NISM conduct a wide range of activities at various levels with the objective of improving quality standards in the securities markets. At NISM, we work in five broad areas: long and short term academic programs, certification for market intermediaries, e learning programs, training programs for working professionals and academia, and various investor education initiatives. We introduce a series on succession planning awareness comprising five episodes scheduled on every Wednesday of April 2026. The previous episode focused on the topic planning for incapacity and minor children. Today we present the last episode of this series on the topic Introduction to Private Family Trust by Mr. Deepak Jain. Mr. Deepak Jain is the founder director of American Academy of Financial Management India and the managing director of NextGen Estate Planning Solutions Private Limited. Now I request Deepak sir to begin with the session.
Thank you, Sahil. Thank you. I'll just share my screen and we can start.
Sure, sir.
So, good evening, everyone. So, we come to this last session in this series of five sessions on succession and inheritance planning, where I'll be talking about private family trust. So, most people think when I talk about a trust, they think about a charitable trust. Let me first make it very clear to you. Today, what we are talking is not a charitable trust. It's a trust created for your family, not for public. So what we are talking today is about private family trust, and I'll be covering in detail what is a trust, why you should create it, how you should create it, what are the good points about the trust, what are the limitations of a trust, what are common myths regarding the trust, right? So I create around 25-30 trusts a month, and I meet so many clients about trust. So I'll be sharing my experience in between in these sessions. Right. So let us start the session. So first, let me tell you, this is a awareness conversation session only, right? This is not legal advice. This is not tax advice. This is not FEMA guidance or stamp duty advice. Every family needs specialist guidance. We are just making you aware, right? So this is a caveat from my side, so that because this is a complicated topic, so it's very you are well advised to refer to these things with a proper professional. We are just making you aware. Right. So let me begin. See, estate planning is not about distribution. When I talk to people about inheritance planning, succession planning, they talk about what goes to whom, right? But the real question should be who will manage after it goes? Who will protect it and how it will be protected after it goes? Who will control after I am not able to control it? Those are bigger questions to answer to ask when it comes to inheritance planning, right? So distribution is only who receives the assets. Control is who manages the decision. Continuity is what happens after it has been distributed and who protects it, who safeguards it. I have children who are minor. Who safeguards the asset from them, right? And as I repeatedly say, sometimes you have to protect wealth for your children from your children also. So what are you doing regarding that? So those are bigger questions to answer just than telling I have given what I want to give, right? So most people leave their wealth. Some people give their wealth on their death, and very few people, after giving wealth, control wealth also for their next generation. If you just only want to give it, I think a will is enough. But if you want to give, control, and protect all three of them, then you need to very seriously think about private family trusts. So there is a hidden gap because what families generally have is this: clear property papers, nominees on bank account, will prepared some years, significant investment, joint holdings. But what is missing is written rules. Who manages the property after the death of the owner? There is a property which is jointly owned by three children. Who manages it? Right? Who decides? Right? If there is some investment, who decides where to invest after the owner? What is the decision making thing? And are there people in the family who can be pressurized to take decisions? And would you leave that those people to a pressure situation after you? And it is very common when it comes to spouses generally. At some age in your life, after one of the partner has passed away, the surviving spouse becomes dependent on one child. Now, this one child starts pressurizing the spouse, change the inheritance plan, give more to me. Problem with the spouse is if they change the plan, they lose relationship with the other children. And if they don't do it, it's difficult to remain in the house. So are those kind of situations, have you thought of those kind of situations, have done something about it? This session is all about these problems, which on the surface don't appear. But when you think deeply, they are bigger problems than just giving wealth to the next generation. Right? Most families, when it comes to inheritance planning, they say a will. Will distributes assets after death. It cannot manage assets after death. I have given wealth to my spouse. How he or she manages it, it's their decision. I can't influence it. Some states or some situations, probate is compulsory because the title without probate which you get is a substandard title which can be challenged by a future buyer. Right? And all wills can be challenged. Those are the issues with the will. Nomination. Nomination only helps the institution, right? Nominee is not the final owner in most cases, and nomination is only for control. It is not for succession. It absolves the institution where the asset is kept, not the receiver. Joint holdings. Many people think I have joint holdings. I own all my accounts jointly with my spouse. So after my death, he or she becomes the complete owner because she is the second owner. But what you don't know is if an asset is jointly owned, it is equally owned. And if it is equally owned, then after the death of one, their share is distributed to their legal heirs or as per their will. That's the problem, right? Survivor does not inherit all the asset. And once it goes to your legal heirs, you cannot control. Power of attorney allows someone to act during your lifetime. Last session we talked about power of attorney, but it lapses at death. Either of the attorney holder or the giver can be misused and does not tell how to use the asset. That's the issue. Right? Many people have family understandings or agreements. Right? It is just trust and shared intent. It is most cases it's not legally enforceable. And relationships and understanding change under pressure. So are these systems which people generally create in their inheritance planning, are they reliable? I'm afraid they are not. You need to think beyond these if you really want to do your proper inheritance and succession planning, right? I'll give you a simple example, and because this is a complicated topic, so you will understand it better with an example. So I've given you a case study. There is this person called Rajiv Mehta, and all of this is fictitious. He is 62 years of age with a total inheritance or total net worth of 35 crore rupees. This is his family. He has a wife named Sunita Mehta who is not financially active, not financially savvy. He has a son called Arjun Mehta who lives in London. He's an NRI, and he has a daughter called Priya Mehta who is married and is in India. right? His daughter has minor children, son has no child. So what does he need? He wants us to plan for spouse security after him. He wants to support the NRI here. He wants to protect the daughter and the minor children. And these are his assets. Right. Now, once I talk to Rajiv Mehta, these are the issues I tell him that can be occurring in your life after you or during your lifetime, which he should think about. Right. Practical risk Mehta family faces and most families don't plan for. First is for the spouse, the wife. She may depend entirely on one child for financial decision and could be pressured to transfer assets if I give the wife the title to this 35 crore of assets. That's first risk. Second risk is son, right? Now, can the son sitting in London manage Indian assets? Can he go to court 15 times and get those assets transferred to his name? Is it possible? What are the FEMA, Foreign Exchange Management Act, implications of a non-resident owning Indian assets? What can be transferred, what cannot be transferred back to his home country? So that's the second problem. The non-resident child inheritance transfer, the laws, they are the second problem his family will face in case something happens to him. Third is his daughter. Daughter inherits assets, but her assets can be jeopardized due to marital disputes or pressure from the in-laws. The in-laws say, we have a better investment opportunity. You have inherited these assets from your father. Give it to us. We'll invest it better. Her husband faces a business failure or a business need. He asks for money from the daughter Priya. Can she say no? Legally, she can. But emotionally, can she say no? No. That spoils the relationship. So those are risks which he should understand. Once you give it to a daughter, whether married son or daughter, I'm not gender biased. Their spouses influence that, and many of us don't like that. We think our wealth is for our children and their children, grandchildren. If something happens to the daughter and these assets go to the grandchild, minors cannot legally control assets. They can own assets, right? Inheritance may go to guardians. Guardian would be the father who might remarry after Priya is not there and has another spouse who's influencing. So maybe the grandchildren's assets are under the influence of their stepmom. Would Rajiv like that to happen? He has a significant portfolio. Who decides where it gets invested after him? Wife is not financially savvy. Son is outside India. Priya may not know it. So once the real person who knows how to invest is not there, there is a big risk of these assets being invested wrongly and there is a loss there, right? Real estate. Real estate, there are three owners, one third each, if he does nothing. And if it is one third each, who decides, who maintains, those are risks. I have a property which my wife should live, and my son and daughter are one third owner of that. Tomorrow, one of them asks, give me my share. The wife doesn't know how to give the share. They force her to sell the house, and she becomes without a residence to live. Those are issues, and there could be disagreements on property. Real estate is indivisible. That's one of the biggest problem with real estate. Decision making. Who maintains? When it's a common property, nobody likes to pay for maintenance. Everybody wants the rent only. Those kinds of issues which people don't generally think. It is your endeavor that you think those kind of things which generally miss people, right? The feeling most families share is I trust my family, but I don't know what will happen if I am not there. This is not about mistrust. It's not you are not trusting your family. It is about protecting the family from pressure, confusion, and emotional decisions. Right? There could be confusion between here, spouse left without support, NRI child is overwhelmed because of the task he has to do, laws he has to maintain, daughter is pressurized, minor children are unprotected. These are issues. Properties get stuck. Good planning protects people, not only assets. What I leave behind are people I love and assets that would be used to protect those people I love. So what is more important, people or assets? Obviously, people, not the assets. Private family trust. What is a private family trust? I'll just explain you briefly. Right? Private family trust. So I'll just give you the legal definition of a trust. So the Indian Trust Act 1882 says a trust is a relationship between three parties where A has given his property to B for the benefit of C. This relationship is called a trust. And I'll just show you how this relationship might work. See, Rajiv Mehta becomes the settler and creates a trust and funds the trust. Right? So he creates a private family trust where he puts the rules, he tells who are the beneficiaries, who are the managers, and includes the investment policy statement there. Where can the trust assets be invested in case he is there or he is not there? So the whole rules and regulations of investment, who gets what, when, in what conditions they don't get it, all of that is written in the trust deed. Now, he appoints a trustee who manages assets as per the trust deed. And he also defines beneficiaries who would receive benefit after him. So he's a person who creates, he gives assets to the trustee for the benefit of the beneficiary. Now, the good part is he can be the settler, he can be the trustee, and he only can be the beneficiary. So I can create a trust for myself for my benefit, but I cannot be a sole trustee in this case. Suppose he creates a trust where he is the settler, he creates it. Beneficiaries only him till he is alive, but trustees is he and his wife. That's a valid trust. So a person can be in three roles, but he cannot be the sole three roles. Then you are trusting nobody. Right? Now, how does it help? You are giving benefit without control. My wife is a beneficiary, but she is not a trustee because she doesn't know how to manage money. So I am giving the trusteeship to my daughter and my chartered accountant. So benefit without control, ownership without control. Written rules protect everyone. I have made provision inside the trust deed. My wife will get this much every month. For her annual vacation, she can get this much. For her medical emergency, she can get this much. The trust would maintain a health and life insurance for her till she is alive of this much. If any amount is required after that, that can be taken out from the trust and paid directly to the treating hospital. All those rules and regulations I create inside the trust, and it works during the lifetime of Rajiv and his death. So trust is something, a will works only after death. Trust is something which can work while I am alive and after I am dead. So I am controlling assets while I am alive. I am also controlling them after I am dead. I am controlling them from my grave through a trust. Simple way to understand is a trust is like a family rule book. Family has created its rule book, which is implemented through a legal structure, which is called a trust. I've just told you who benefits. Sunita receives monthly income. Arjun and Priya receive on specific terms. For Arjun, we can say tomorrow he wants to buy a house in London. This much percentage money can be, if he asks, can be given. Priya, Moment she has a child, this much money I'll give her. When her child goes to school, this much money goes from the trust. Right? If she wants to go for a foreign vacation, this much money she can ask for the trust. So there is terms. Or I can make it dependent on the ages of the children. Priya turns 30, she can withdraw 5% of it. She turns 40, another 5%, and so on. Who manages? A trusted family member or these children themselves or a professional. Anybody can manage. What can be sold? Till Sunita is alive, the house cannot be sold. But the commercial property can be sold. But if it is sold, money would come to the trust and reinvest it as per the IPS, put inside the trust. When do minor get children? Priya has some children. I can say the day my grandchild turns 25, he gets this much. When he gets 30, he gets this much. When he gets 40, he gets this much. And this much is retained for the grandchild, and this much is retained for the children of grandchild. It can be multi-generational. If there, I wanted to do, if somebody needs care, extra care, medical care, some disease which needs extra effort, those are taken care by the trust, by the trustee. So I have created a trust deed which has all these rules written. What a trust is not. Many people think trust is only for the ultra rich people. Wrong. It is usually beneficial for everyone who has complexity. Minor children, vulnerable spouses, multiple property, non-resident beneficiaries, uh, family feuds, disputes, and inability of a family, of a child to manage money. If you have such issues, trust is required. Trust means I do not trust my children. No, it doesn't mean I don't trust my children. It means you want clarity and protection for them, not from them. Trust avoids all taxes. Wrong. Treatment depends on the structure and law. Trust is not a tax saving tool. Please don't think like that. Generally, trusts are tax neutral. Trust can prevent every dispute, not possible. But trust can reduce disputes. That is possible. A trust is too complicated for my family. No, it's not complicated. I have seen many trusts running. Even a simple person is able to run a trust, and you can appoint advisors and other professionals to help your family run the trust after you. Once created, trust cannot be changed. Revocable trust can be changed anytime till the settler is alive. But even if it is irrevocable, it can still be changed. Some clauses will put like that, these are changeable, right? In trust, there are three main people which you should think about when you're talking about trust. First is called the settler. First is called the settler. Settler is the person who creates the trust. In our example, Rajiv Mehta is the settler. He decides the purpose and rules. He gives assets to the trust. He writes who gets what. And he signs the trustee. Right? Settler, should a settler be an individual? Settler, the law says settler can be a person. And when the law says, the trust law says settler can be a person, person means non-individuals can also be settlers. A company can create a trust, HUF can create a trust, a society can create a trust, right? A association of persons can create a trust, a club can create a trust, and two or more individuals together can create a trust. All of that is possible. Trustee is the person who manages the trust. He is the manager of the trust. He holds the assets, he manages it. He is bound to follow the trust deed. Otherwise, it is breach of trust, where apart from a civil case, a criminal case can be also filed against the trustee. Cannot personally benefit if he is just the trustee, not the beneficiary. And he is answerable to the beneficiaries. Last comes beneficiary. In a private family trust, the family member who benefits from the trust is the beneficiary. In our case, the spouse and children and grandchildren are the beneficiary. They receive income. Rights are defined by the trust deed. May benefit without controlling directly. So they might be beneficiary but not trustee. and they are protected by the trustee duty of care. Trustee is a fiduciary person. Who is the settler? He's the creator of the trust. He decides the entire purpose of the trust, contributes assets, writes all beneficiary and control rules, may change the trust if while alive if it is revocable, like I've told you, which is stay into effect. So what does the settler decide? Who are the beneficiaries? What assets go in and when? I can give assets while I'm alive, or I can make a will in favor of the trust. See, two types of assets would be there when we talk about assets being transferred to the trust. First are real estate. Second are financial and movable assets. Financial and movable assets can easily be transferred to a trust. If I have mutual funds, I'll dematerialize mutual funds. They come into my demat account. I'll open a trust demat account and do an off-market transaction, and it goes to the trust. Problem is when you transfer real estate to the trust, it has to be retitled in the name of the trust, and that retitling costs the stamp duty, which is 6 to 7% in most states. In Maharashtra, it is 3%. Otherwise, it's 6 to 7%. So I have a 10 crore rupees property and I want to transfer it to the trust during my lifetime. I have to pay 70 lakh rupees as stamp duty, which most people would not be ready to give. So in those cases, what we do is we ask this person to create a will in favor of the trust. Now it is transferred on the death of the owner of the property, who might be a settler, who might be anybody else. So can Priya, his wife, transfer her assets to this trust? Yes. Settler is the creator. Transferer can be anybody. The trust is allowed to receive gifts. Wife can give it, his son can give it, his daughter can give it. But I have to keep in mind of the gift tax implication. So only people who are covered by section 56 subsection 10 rule of specified relatives whom I can get unlimited amount of gift should be the transfer. That clause I'll put in that trust. Right? As I told you, settler can also be a beneficiary. I can create a trust for my benefit. That is allowed. I might be sole beneficiary. I could be beneficiary with other people. Right? That's okay. Who is a trustee? Is a person who manages the trust assets. Right? But when he manages the trust assets, he makes investment and other decisions based on the rules set in the trust. So does he have complete freedom? No. He is restricted by what is said in the trust deed, what is allowed and what is disallowed in the trust deed. He has to follow trust deed, cannot act outside the deed. Even if a beneficiary asks him to do it, he'll say, I'm not allowed to do it. Act for beneficiary's interest only. He has to keep proper records, maintain accounts, share those accounts with the beneficiaries maybe once a year. He has to look at all compliances. If the income tax return has to be filed, it has to be done. If there's a GST has to be done, it has to be done. If any TDS implications are there, he has to deposit TBS. So compliances, the trustee is responsible. And he is also should seek specialist advice when required. Engage lawyers, CAs for complex decision making. Right? Please remember one sentence. The trustee manages assets for the beneficiaries, not of the beneficiaries. I repeat again, trustee manages assets for the beneficiaries, not of the beneficiaries. He is managing assets which in future would be of beneficiaries. Those assets are still not beneficiaries. So he has every right to say no to a beneficiary. You're getting my point? He's a very, very important person who ensures that trust deed is being compliant with, and tomorrow if he doesn't comply with, you can file a criminal case against him under the breach of trust act. Who can be a trustee? Family members, professionals, institution, a trust company. There are many trust companies in India. Or it could be a combination of family member and a professional and an institution. All of them combined. I can make as many trustees in my trust as I want. Who is the beneficiary? Beneficiaries are family members who receive benefit from the trust. A beneficiary may receive income or support without holding or controlling assets directly. That's the basic difference in a trust. We have separated ownership and control, right? Ownership is of the trustee, control is also of the trustee, but beneficiary becomes owner when that ownership is transferred from the trustee to the beneficiary. I can give regular income. Suppose in this trust, Rajiv ji says, give Sunita 2 lakh per month from the trust, or he says, give give money worth 15 gram of gold every month to my wife after I die, till she's alive. Now it is inflation adjusted also, right? Medical support to wife, to children, children of children, education support, housing support, stage distribution. Like grandchild receive one third at 25, one third at 30, and one third at 35. I can write those things. Specific purpose. I'll allow Arjun, my son, 10 crore rupees any time once in lifetime to start a new business if he shifts to India. I make a provision like that. What is a trust deed? It is the document which has this rules and regulation. So in this, there should be a purpose why we are creating the trust. Purpose could be protect, why ensure portfolio is managed wisely, ensure that my daughter has access to my funds after my death on her terms and all those stuff. Settler, you have to tell who is the settler, who is creating it, who will manage it, who are the trustees, who are the beneficiaries, what are the assets which are going into the trust, and what are the future assets that can go into the trust. What are the distribution rules? What are the restrictions? So I have created many trusts where there is a restriction that spouses of my children can never become trustees and beneficiaries. People add those rules. In-laws of my children can never become trustees and beneficiaries. An adopted child of my child will not be considered as a beneficiary. These are rules which people tend to put in their trust. So this is a restriction. My family home, which is in my village, can never be sold. It will only be passed from generation to generation. It's a restriction, right? What are the review requirements, right? So what can beneficiaries ask the trustees? What accounts can they ask? Is if an auditor is appointed in the trust deed, what would the auditor audit so that the trustees remain in check? Those are things we can add in the trustee. What assets can go into the trust? I have told you more financial assets. Yes, they can go into the trust. You have to see gift tax in section 56 so that there is no gift tax implication. Equity shares, you have to see capital gains and implication. Generally, when you transfer assets to a trust, there is no capital gains because of a section which is called section 47(3) of the Income Tax Act, which says any transfer done to a irrevocable trust, there is no capital gain. So generally, if I create an irrevocable trust, generally there will be no capital gain being attracted by the transfer. Real estate, it's generally done better via will, not through lifetime. But only thing is, if a real estate is left outside the trust, it doesn't get the protection. So suppose I leave my real estate through a will to a trust. A problem is if will can be challenged, this asset will never be moved to the trust. Second, my creditors, separating spouses can still claim it because it's outside the trust. It's not inside that protected box I have created. Business interest, I can transfer shares of my business to the trust. The only problem is when you have proprietorship, that is very difficult to transfer to a trust. Other forms, LLPs, private limited companies, etc., etc., if they have shareholding kind of structure, I'll transfer those shares to the trust, right? Generally, in that case, I would always say don't mix your personal asset with business asset. To create two separate trusts, a business trust and a personal trust. Business assets for business trust, personal asset for personal trust. Don't commingle both. because risk generally would come from business, and I don't want to keep business and personal assets together so that risk of one is transferred to the other. That's the reason I'm creating the trust, to separate both of them. If you have NRI linked assets, they can be transferred to the trust, but only remember Indian trust for Indian assets, foreign trust for foreign assets. And if you check FEMA requirements, is it allowed to be transferred and controlled? Like agricultural land, a non-resident Indian cannot hold agricultural land, cannot be gifted agricultural land. They can inherit agricultural land. But even if they inherit, they have to sell it to an Indian, not to a non-resident Indian. Those kind of restrictions you have to check. Jewelry, yes, control, I can give it to the trust. Many ways of giving it. Either I do a gift deed and give it. Second is I open a bank locker in the name of the trust, and that bank locker holds the jewelry. So it can be owned by the trust, and we make a gift deed in favor of the trust. That is possible. Right. Important parts of a well-designed trust. Purpose, why you are creating. Who are the beneficiaries? Who are the trustees? And when it comes to beneficiary and trustees, who are successor beneficiary or successor trustees? Now, this family which I have discussed, do I know the order of death of them? No. That order of death can be anybody. And each order of death, the trust would have an answer about control and ownership, distribution. What if what if Priya goes before all of them? What happens to her share? What if son dies without marrying? What happens to his share? What he dies after marrying, not having a child? Will it go to his spouse? So those kind of situations you have to build while you are creating the trust, right? Assets, what goes in now, what goes later. Distribution rules, restrictions. Who is the protector? You can also appoint a person who is over the trustees, who is not a trustee. He doesn't run day-to-day affairs, but he overlooks the working of the trustees, right? So it's a safety layer, right? So there are different types of trust, revocable and irrevocable. Revocable trust is a trust where the settler can change the trust anytime he wants. And second, he can extinguish the trust anytime he wants. He can dissolve the trust anytime he wants. Revocable trust give more power to the settler, but the problem is revocable transfer of an asset is not considered transferred by the civil law. So the asset protection doesn't kick in the revocable trust. It only kicks in a irrevocable trust. If the purpose is to protect and ring fence assets, irrevocable trusts are better than revocable trust, right? Specific and discretionary trust. In a specific trust, I tell this person receives this much. In a discretionary trust, I leave it to the judgment of the trustees. So I say my wife will decide which of my children will get what after me. Till I'm alive, I will decide. After both of us, this discretionary trust becomes a specific trust where I have not defined the rules if my wife has not already defined it after I die. So those kind of situations I create in a discretionary trust, that is specific trust. What is right for trust? What type of trust is, are all beneficiaries added with similar need? Consider specific. Is there a vulnerable minor or dependent beneficiary? Consider discretionary. Is a creditor or divorce protection important? Consider discretionary, because discretionary person who is facing the risk, the trustees will not give that person anything till the risk has gone. Right? It is simple, predictable. I know 50% to both my children. There is no issue with them. They are good managers of money. They have good relationship with their spouses. There are no creditor issues kind of thing. Maybe I create a specific trust. Right. So there are 8 steps to create a trust. First and most important is family discussion. Family discusses, decides, finds out the pain points, finds what they want to happen after them, right? Then you map the assets. What are the assets involved? Then you choose who will be the trustees, choose beneficiaries and rules of distribution to the trust. Based on that, you draft the trust deed, you register it in the sub-registrar office. After registering, you start transferring assets to the trust. But before this, you have to apply for a PAN card of the trust, open the bank account, demat account, and other accounts of the trust, and then start transferring assets to the trust. And You review annually whether it's working fine or not. If any tweak is needed, you can tweak it, right? So this is generally a trust generally takes 3 months to set up and start running. So if you ask me what time does it take to create a trust, generally in my experience, it takes around 2 to 3 months to create and run. It's a complicated document. Even knowing what you want would take 1 month. Then draft, redraft, register, and all those stuff. It takes time. So comparison of trust, I have done this. I will not do this because will is only after death, and problem is will doesn't manage assets after transfer. I give assets to my wife through a will, and then I say it should go to my son. Problem is will is only one time play. After it goes to my wife, her will is important, not mine, right? And it does not control after giving, right? Nomination nominees is generally the distributor, not owner, right? And that's the problem. Most assets nominee is not the owner, they are just the distributor. So nomination does not decide final owner and does not decide final controller of the property. Power attorney, it's only for controlling while the person who is given the power attorney is alive. On the death of either of them, it becomes a null and void document. How a trust compares. Power attorney lapses on death, trust continues after death. Power attorney has no governance, and power attorney can be misused. Trustees cannot misuse because I have put the clauses, this can be done, this cannot be done, right? So I'll move ahead. I'm short of time, so I'll just move ahead. I'll give you some use cases where trust is important. Protecting survivor's voice. Your concern is my spouse should never be dependent on pressured or feel financially helpless, right? She or he should be comfortable. Uh, so trustees provide regular income without requiring decision from the spouse. Even if some child says do it, she can say, "Beta, I want to do it, but I'm not allowed to do it." Right? She or he is taken care for their medical expenses, right? And gives them something which is very important, financial dignity. The biggest issue with money is having money does not guarantee respect, but having no money guarantees disrespect. That's the issue. So most important thing at old age is financial dignity, and that is compromised if I have to ask money from someone. Trust gives that financial dignity to your surviving spouse, right? In some cases, people say if my spouse remarries, the that benefit stops. That I can put inside a trust, right? You might have children who are living outside India, that there are issues of maintenance of property, transferring property to the name of the non-resident, right? There are repatriation rules. So India FEMA laws allowed 1 million USD to be transferred every year, right? So even if I have a asset worth say 50 crore rupees, it can't be transferred at one go. It has to be transferred in 5 years at least it will take, right? So how do I keep that money? How do I secure that assets after selling? Then many countries have inheritance tax. If I inherit assets, I have to pay tax in the local country. I'll give you a very important use case here. Many of us have ESOPs while we were working in US. Later, we came back to India and became Indian resident. Now, US has a law that there is an inheritance tax for US people. It starts after 13.5 million USD. For a non-US person, it starts after 60,000 USD. So I have, suppose, 1 million USD ESOPs in US. After my death, 60,000 US would ask nothing. After 60,000, whatever is remaining, 40% is the inheritance tax my children will have to pay before they get the assets. That's an issue. Trust can avoid those kind of issues for you, right? Double taxation risk. Trust allow because you are not the owner, your child is not the owner, the trust is the owner. Till it goes to the child, there is no taxation. Married daughter protection, I have told you, right? If there's a married daughter and they get pressurized from spouses or in-laws, you can do that. If marriage is strained, you can ring fence that. You can give assets to their children, right? Right. So those kinds of minor children, you can protect them and see how I protect them. Ages 0 to 18, trustee manages. 18 to 25, we give some power to them, but still is supervised access. 25 to 30, some percentage is released to the child. 30 to 45, second release. 35 and above, full distribution if the child asks for it. So I am controlling it over the life cycle of my child, the distribution. That only a trust can do. Real estate family, real estate heavy family is big problem. Because when it is owned jointly, there are so much issues about who controls it, who gives it on rent, who is the tenant. Son says give it to this tenant, daughter says give it to this tenant. Who decides? There's decision paralysis, and who suffers? The family, right? Who maintains a joint property? Nobody wants to maintain. Everybody wants the rent. Those kind of issue we can resolve by putting these assets inside a trust. There are clear rules made by the person who created that property. This is how it will be managed after me. This person decision will be final, and this decision will be final. Right? Many assets, if they are sold fragmented and sold, the value is loses. But if it is sold as a consolidated thing, the value is uh, preserved. So I have a rule of right of first refusal. If anybody wants to sell their share, you have to first offer to the other family. Or it could be tag along clause or a drag along clause. If you want to sell your share, you have to sell my share also. Those kind of options I can build inside the trust, right? Which generally people don't do it, and the reason because of that the family suffers. Business families, big issue is about who controls the business after the death of the person who has set up business, right? I have two children. One is involved in the business. Second is a doctor. After my death, both become owners. Now, this doctor son would start interfering the business and make it difficult for my son who is managing the business to manage the business. So can I separate ownership and control? I can do it in a trust where the doctor son gets the share, but control is with my the other son. And because he's controlling and managing this business, I reward him from good performance and do not reward him for bad performance. Right. Second, business risk should not reach personal assets. Generally, risk would come from the business. My business has a creditor issue. My business fails. I have given personal guarantees. Tomorrow, if I have given personal guarantees, my personal assets are at risk. But suppose I don't own that personal asset any longer. It is inside a trust. So who owns the trust? And I have structured it as an asset protection trust. Now the entire property is safeguarded because I am not the owner and liability is on me. So it ring fence. Business liability cannot reach family wealth. Right? The many reasons why business should be moved to a business trust because it ensures continuity of business, ring fencing of the business, allowing people to control business without ownership, right? Decide on major decisions. This much percentage of money would be invested back into the business. Because when it becomes a family business, everybody wants to milk money from it. Nobody wants to give back money to the business. So those kind of issues I can sort out while I'm alive. Financial assets and portfolio managing. Who manages the portfolio? Who decides where to invest? I have made an investment policy statement inside the trust which says the asset allocation would always be not more than 70% in equity at any time. Even in equity, not more than 1% exposure in a single company. Only large cap is allowed, no mid cap, no small cap. Portfolio churning rates should not be more than this. I put all the rules while I'm alive so that my children who are not financially savvy or don't know investment are taken care of. That I do in a trust, right? If you have elderly parents, the risk of misuse, etc., can be taken care of because they cannot be forced to sell things and sign on documents because they don't have the authority to do it anymore. If you want to protect family disputes, Trust is a very, very important document to create where rules are set by the person who is creating the trust so that there is no dispute chances or nobody can say, I was not informed and this is your decision, not his decision. If you want to give charities, trusts are a very, very good way of doing that. They allow your name to be alive after you die, right? So trust, I have told you mostly about trust, right? I will not spend time on these. Questions your family should ask first is who in our family should need protection? Who should have benefit, not full control? Whom do we trust as trustee? And who is the backup for that trustee? What assets are complex or at risk? What assets do we want to give directly to the beneficiary? What asset do we want to control and give? Right? And rules how it's to be distributed. Right? Concern, what worries you? Are there any existing disputes or strain relation? What is the biggest fear? Right? What do we want to be remembered for? How many people will cry when you die? Do we want part of our wealth to support a cause? What values should you transfer to the next generation? Right? And readiness of the documents which you have. See, sorry, is there? So, so can you tell where did you miss me, Sahil?
Yes, sir.
The last part was not done, I think. There was a
You can explain that as we have few minutes only, sir, in our hands. So
yeah,
that's why.
right. So see, family trust is not about mistrust. It's about clarity, care, continuity, and peace for your family. It is not about who gets what. It is about writing the rules before pressure arises, protecting people you love, and giving next generation a calmer way to take care of your wealth. Right. So that's all from my side. I'm open to questions.
So
I
there
hope
are
I
few
was,
questions.
yeah, I hope I was able to explain the concept and need of the trust to you. So first question is, does a trust protect asset from divorce, payout, or alimony? If it is structured properly and at the right time, it can. Not guaranteed. I am asking you to give real estate to the trust via will to avoid stamp duty. It is transferred during your lifetime. The gift stamp duty is 6-7%. Because it has to be retitled in the name of the trust, and the sub registrar will charge 6 to 7% to transfer it. Settler can be a trustee while he or she is alive. Agricultural land can be transferred to the trust in some states, and some states there is a restriction on transferring. Trust cost is to create is around 2.5 to 3 lakh rupees. Ongoing expenses, there's no ongoing expenses, only yearly ITR has to be filed for the trust. There is no will made Minesh which cannot be challenged. Yes, you can create two trusts, one for your son and one for your daughter. And it is always advisable to create separate trusts for your children so that there is no commingling of assets and there is no fight on the decision making inside the trust. Trustees does it either for themselves or they can be paid for their services. Equal is very seldom fair, sir. Generally, unequal is fair. See, the problem with HUF is you can't set rules in an HUF. The rules are set by the law. Who will be the next karta, who gets what, when, all of that is set by the law. In the trust, I decide everything. Second, trust gives asset protection. HUF don't. Your share in your HUF can be taken away by your creditor. Yes, Omkarji, we can create something which is called a matching trust, where I can say that your living expenses of 10 gram of gold I am guaranteeing for lifetime. But if you want more than that, show your ITR to the trustee at the end of every year. Whatever you earn from your own efforts, that much I will match from my trust as a reward for you. There are always, settler is not required after death, only trustee is required after death, uh, Vishal Kumarji. And we will always have a successor trustee in place. The provisions would be there in the trustee. We will share the recording of these sessions with you. You cannot create a will with same conditions as trust because will is only one time play. It is not play, rewind, and play. So once it is executed, will extinguish. So capital gain on a trust property is the capital gain of the original transferor. The cost of acquisition is the original transferor. I own my property, which came from my father who bought it. I transfer it to the trust, and trust sells it. So cost of acquisition is my father's with cost inflation index and rules, etc. This is not a charitable trust, Ashokji. This is a private family trust. It is registered with the sub-register office, not with the charity commissioner. Trustees and beneficiaries can collude, and for that reason, we create an auditor inside the trust. Trust rules can be revised if it's a revocable trust. Sanjeevji, you have to always take care of freedom and restriction. There should be a balance between that. Right? Too much freedom is bad and too much restriction is bad. In a trust deed we structure, we try to balance it. Right? There should always be two trustees in a trust. Minimum number of trustees as per Indian Trust Act is two. Settler can be a trustee while he or she is alive. So, Sahil, I have answered the questions. I know it was little fast because of the time constraint and the topic was complicated, but you can always look at the recording of this session again and get more idea and get more knowledgeable about it. Sahil, that's all. I think we are done with it. Uh, we can have the feedback now.
Yes, sir. I think you have answered all of the questions. As I can see, there are lots of questions. Where can we find the recording? You can find the recording on the NISM Investor Education webinar YouTube channel and also on NISM website. Okay. Also, do we have any? Okay. Please share recording for all excellent. Can you suggest any book? Also, sir, there are few attendees who are thanking you for the webinar.
Thank you.
Take care. Also, sir, I am sharing the next series, which is the May month series registration link for the attendees, so they all can register that. Yes, so you all can wait. Yes, so you all can register with the given link in chat for the May month series, and the speaker will be Harsh Rumta sir for the series. Yes, I think now we can conclude the session, as I have stopped the feedback form as well. So thank you so much, sir, for sharing your time and knowledge throughout the episodes which we have means done. And also thank you to all the attendees who joined each and every episode. So do make sure to register for the next episode series as well, means next series. So yes, thank you, sir. Thank you so
Thank
much.
you. Thanks a lot. Thank you.
Thank you so much, sir. Thank you
Thank
all.
you. Thank you.
Now I request IT team to close the session.